Well, I'm going to go ahead and get started. It's 10 o'clock on the dot. I'm sure we're going to have more people jumping on, but we've got a lot of information we're covering today. So thank you all so much for joining. This is our second virtual caregiver workshop. My name is Candace Christensen, and I'm the coordinator for the Caregiver Coalition of Northeast Florida. You probably see a lot of emails and stuff. Those are mostly coming from me. We started these workshops in response to the COVID-19 crisis. We wanted to be able to bring the caregiving experts and resources right into your homes. So I'm glad you could join us for this morning's session. We're talking about the legal aspects of caregiving. We have two experts joining us today. They're going to share their most valuable tips and hopefully make the legal tasks a little bit less daunting. So first we have Caroline Emery, attorney at law. Caroline is an attorney licensed over 34 years and focuses on guardianships, probate, and estate planning, including planning for Medicaid, asset protection, and furry children. Prior to establishing her law firm, Caroline was the court's general counsel for Duval, Clay, and Nassau counties. She's also the past president of the Jacksonville Bar Association. We also have Carla Trinka Conley, an attorney with Berg Bryant Elder Law Group here in Jacksonville, Florida. Carla joined Berg Bryant in 2016 and leads the legal team on guardianship cases and volunteers her time to teach guardianship education training classes every 3 months. So thank you both so much for allowing us your time and expertise on this Saturday morning. I would quickly like to go over some housekeeping items. First off, the session is being recorded, so it's going to be posted to our website. So all the cameras and microphones, except for those of the panelists and myself, have been turned off. We ask that you remain muted until we reach the Q&A session. If you haven't already, you might want to turn on speaker view in the top right of your Zoom screen. This way the screen isn't so cluttered with everybody attending, it'll just highlight the speakers. Third, if you find yourself with any questions during the first half of the session, please type them in the chat box and I'll make sure that they get answered. When we begin the Q&A, you can still type your question in the chat box and then I'll be reading them all out loud to be answered by our experts. At the end of the session, we'll be holding a short poll on what you liked and didn't like about the session. This way we can kind of continue to improve the sessions month by month. Everyone who fills out the survey will be eligible to win a $50 Amazon gift card. We'll reach out to the winner by email after the session. And then lastly, with the number of attendees we have, we could run into some technical difficulties. If something should happen, please be patient and we're going to try and resolve them as soon as possible. We're all kind of learning and adjusting to the virtual world, so we appreciate your patience. I am now going to hand the virtual microphone over to Caroline. She's gonna share her presentation. Caroline, let me stop my screen share real quick. There we go. Caroline, if you're speaking, I cannot hear you.
Okay.
Candace, oh, now I can hear you.
Yeah, are we ready?
Yes.
Okay, thank you, Candace.
Mm-hmm.
You know, there's a lot of information I need to share with the caregivers and very little time. So I might be going through these slides fairly quickly, but just bear with me and you will get the PowerPoint after this workshop. You know, now more than ever, it is important for you to have a full estate plan in place for the person you are taking care of. For example, anybody can become incapacitated at any time. One example I have here is my sister's pastor. He was the very first COVID-19 case in Washington, D.C., and that's why he made the news. And he's very young, very healthy otherwise. And then he had COVID-19 back in March and was hospitalized for almost a month and on a ventilator for several weeks. And now it's June 20th and he is still recovering. So, you know, anybody can be incapacitated at any time, like I said, for various reasons, as you can see here. So it's best to be prepared. So I ask you, what level of estate planning protection is in place for the person you are taking care of? I like to think of it as getting hit by a semi. No protection at all is getting hit as a pedestrian. And that's the same as having absolutely no estate plan in place. The second level would be like an old car with no airbags, no safety features, kind of like the old days where the driver would do this to protect the passenger instead of having a seatbelt on. And that's the same as having just internet forms or free forms or having an estate plan that is outdated. Now, the best protection is like having being in a new car with all the safety features that we now have. And that's the same as having a full, robust estate plan in place for the person you are taking care of. So what is a full estate plan? Well, these are the things that I provide my clients, and it is like having a full toolkit with all the tools that somebody might need just in case of any problem that might come up. I will go through all of these documents through my presentation, but for now, on this slide, I would like to bring your attention to this online access card that I provide my clients with. And it reflects what the allergies are of the person, who to contact, and it provides access, online access to the various documents in their advanced directives. And this is good for first responders, hospitals, and even family members. So they can access the card and the documents online rather than having to rush to the house and figure out where did mom or dad keep those papers, where did they file them. So this is an excellent card to have. Another thing in the toolkit is the trust. Basically, the trust provides specific legally binding instructions. They are costly, both to establish the trust and to maintain the trust. Often people forget that part of it. And they do not necessarily avoid probate, and they are not always necessary. Now, the last will and testament, that is essential. That is a big part of the toolkit. And many people don't have this. They hate going to a lawyer to do their will. It's like right up there with like going to the dentist. Who likes doing that? And often I hear people say, well, I just don't have enough to give, so it's not worth having a will. Well, it's not how much a person has, but it's who should get what. That's what's important for the person that you're taking care of. If they want things to go to certain people or to stay within the family, then they need to have a will, because without a will, the Florida law dictates who will inherit and who doesn't. For example, stepchildren do not. So without a will, often the result is a lot of family drama and the risk of losing precious heirlooms that have been in the family for generations. Now, a will handles your matters after life, whereas advanced directives protect someone during their life. So it's important for your person to have the advanced directives as well. Just like it says, advance is before they become incapacitated, and directives are instructions. The first document as an advanced directives, as part of that, is durable power of attorney. Best way to remember this is that it's all about money. Just think green dollar signs. It's all about managing the finances. It lists or names a trusted person who will have legal authority to manage financial matters and to protect the person's assets if the person becomes incapacitated. Now, for caregivers, it is important to be aware that it is best not to be named in the durable power of attorney as the agent, because there's an appearance of a conflict of interest, of impropriety, and there's a risk of liability. The next thing in the toolkit is Health Care Surrogate Designation Now, who is going to make medical decisions for the person that you're taking care of? Who is going to say, no, I want mom to go to Baptist Hospital, not Memorial Hospital. I want her to have this doctor, not that doctor. She should not be on that medicine because she's allergic to it. Who's going to be able to have authority to make those medical decisions? This healthcare surrogate designation names somebody who's trustworthy, who can do that on behalf of the person if the person becomes incapacitated. And it provides authority to allow that person to give consent on behalf of the person and to communicate with the medical staff. The next very important document in the toolkit is a HIPAA release form. Often this is not included, but it is extremely important to have this in as part of the estate plan, because it authorizes the people that are listed in the form to have access to all prior medical records. This would include x-rays, MRI reports, lab reports, medical records from all facilities, not just a particular doctor's office. And this helps facilitate second opinions from doctors once the person listed on the form is able to access the medical records. So another important document is the declaration of pre-need guardian. Just like it says, pre-need, before it's needed, before the person becomes incapacitated. And it names trusted people to act as the person's guardian, either guardian of the person, meaning taking care of personal matters, like healthcare decisions, or of the property, the person's finances. Now, if you or if the person you're taking care of does not have a declaration of pre-need guardian, then the court will step in if a guardian is needed and will appoint who will be guardian of the person or the property. And I have here an angry judge, because that's how that person will be, or you will feel. That's how you'll perceive the judge, because the judge might appoint somebody who was not intended, like perhaps an irresponsible child. The next important document in the estate plan is the end of life, or the end of life wishes that are expressed in writing officially under a living will. This lets the medical providers know whether or not the person wished to pass naturally or have life-prolonging procedures used. It became really well known during the Terry Schiavo case, and this was there was an argument between the husband and her parents and siblings, and these arguments lasted for about 15 years in court. It cost them $100,000 and more to resolve the matter of whether or not she should be kept on life-prolonging machines and procedures. So if she had had her wishes in writing, it would have been resolved immediately once there were two physicians that decided that there was no chance of recovery. That's always in the living will. And also whether or not she should get pain medicine. That's pain medicine is always, I've never seen it not be included, but it's always included so that at least they can have pain medication no matter what. Now, even if the person you're taking care of has a living will, it should be kept current, especially during these days, in these days when we're facing so many things. For example, the person's opinion about whether or not to be on a ventilator might have changed since they did their living will, since now it's a common treatment for COVID-19. I also now include whether or not the family would like or insists on having family visit, even virtually, if visiting in person is not a possibility. And I also include a clause about pets if the client has pets. whether or not they would like their pet with them at their bedside at the end, to give comfort and to help also the pet understand what's going on and where their parent went. So, you know, pets are very much like family members. If you have your own pet, they're part of the family, and they rely on their parent to take care of them until the end of their life, until the end of the pet's life. And they are very traumatized usually when the parent goes missing for a while. So I put together a booklet with full instructions. I call it the Golden Guide, and it provides comprehensive instructions that the pet parent pet parent provides. There's some background noise at Candace, if you can see who's doing that. Okay, so the Golden Guide, yes, it provides many instructions that the pet parent, it's herself or himself fills out. One of the instructions is about vocabulary, the pet's vocabulary. For example, a pet might be used to saying, to being scolded by saying, "Oh, honey, you know better than that." That's how I punish mine. And then my cat stops doing what it wasn't supposed to be doing. But without the instructions, a new guardian might not know about that and might yell and say, "No, bad dog." So that's an important part, an important element of the instructions. There are many others as well included in the guide. Now, we've covered all of the things, all of the tools that need to be in the toolkit for the good estate plan. What is next is knowing that the timing is critical, it's crucial. Advance directives must be signed before the person becomes mentally incompetent and unable to sign legally. Also, all of those documents need to be properly prepared by someone who knows what they're doing, because if they're insufficient, then Plan B, if the timing's off or if they're insufficient, Plan B is a guardianship. And guardianships are very expensive, and it involves the court monitoring. And so, as a caregiver, if you notice that the person you're taking care of is becoming forgetful, forgetting to take medicine, forgetting to eat properly, or even subject to exploitation, then make sure that the person you're taking care of has a lawyer who will prepare those documents before the dementia becomes more advanced. Now, Carla is going to cover guardianships more fully and also how to properly get those documents signed so they are effective. Okay, so now here's your checklist. And these are the things that you want to make sure are included in your plan in the plan for the person you're taking care of. Make sure that they have a will or trust and all 5 advance directives. And when looking for a lawyer, check out the lawyer's website and make sure that they know about and primarily or solely is even better, focus their practice on these areas: estate planning, guardianship, probate, Medicaid planning, asset protection, all of these things that go into protecting the senior or the person that needs to be taken care of. And it's like, if you don't have those, then it's like having a toolkit that's missing any tool that's very important. And make sure that the lawyer does not just dabble in these areas alongside of other areas like criminal law or landlord-tenant or business or bankruptcy, divorces. Just make sure they focus on these areas that Carla and I are doing. As a primary focus. Okay, so the other important thing from here is the passwords. Make sure that somebody is designated to know where to find the passwords. Somebody trusted, obviously, but the person should have somebody lined up so that if something happens, a person will know where to find the passwords. I'm not saying give out the passwords. I'm just saying somebody needs to know how to find it. Otherwise, it is a nightmare and it's a disaster trying to get everything resolved. So that's the basic checklist. And now I ask you again, think and ask yourself, what level of protection is in place for the person you are taking care of? Is it absolutely no protection? Is it the minimum amount of protection? Or is it the best protection with updated documents that the documents that we've talked about? And if they need any assistance, well, as past president of the bar and owner of my firm, I am proud to say that my bar's business is open and CDC compliant, unlike a lot of the bars that we have here in Jacksonville Beach. So I am good to go, and I'm more than happy to assist anybody who's got questions or needs assistance. My contact information is here, and it will be in the PowerPoint that you will be receiving. So now I turn it over to Carla to discuss how to sign these documents properly, and also guardianships in case any of these documents fail.
So, Caroline, I do want to quickly remind everyone, while I work on sharing my screen for Carla's presentation, that this is a lot of information, and we're going to be sending the resources and the PowerPoints out to you via email after the session. So whether you're joining by phone or through the Zoom app, if you're scrambling to write something down, we've got you covered. We've got your back. We're gonna be sending everything out through email. So I'm gonna go ahead and turn it over to Carla. Go ahead, Carla.
Thank you. Good morning, everyone. So I am here to talk about today where Caroline left off, which is how we are going to go ahead and get all of these documents, now that we know how important they are, signed. So in the wake of COVID these days, we're getting a little creative with how we're getting all of these documents signed. So some of the ways that we're doing all of this is if you call up an attorney's office, Caroline and I both have very functioning and extremely clean offices, but we're also offering, and a lot of attorneys in the area are offering, what we are calling drive-up signings. You come in your car with your mask on and abide by the 6-foot social distancing rules, and every document is handed into that car and we sign from a distance. Now, not everyone is mobile, so we have a lot of clients who are unfortunately at facilities or hospitals. And so those facilities are understanding that a lot of our clients need these documents in place that are validly signed so that we can get a lot of help. And so a lot of those facilities are authorizing for us attorneys to come out and see people through a window so that we can visually see those clients signing the documents. And sometimes they'll even grab the clients and wheel them out into a courtyard if we can do that, or we get a little creative. And so one of my recommendations always is to keep that open and honest communication going with any of those facility administrators. We catch a lot more with some honey than we do vinegar. So we always tell people, put a smile on that face and be persistent and make sure you're talking to the right people. So call up those administrators or those caregivers to make sure that we can kind of facilitate those signings. And then the last thing is, although the law is a little slower than medical advancements, we are in Florida doing a lot more video conference signings over Zoom or FaceTime. This is the future. This is the present right now. And so we do have a lot more technology that's become available, and there's been some law changes that allow for clients to speak directly with their attorneys and witnesses and facilitate those signings. And let me talk about that on the next page, exactly what those witnesses and notary requirements are all about. So Caroline did a wonderful job of explaining those 5 advanced directives: the Health Care Surrogate, the Power of Attorney, HIPAA document, living will, and pre-need guardian. There's also the 2 other types of documents after we're gone, which is that last will and testament or trust. There is a difference between a best practice, right? What the golden standard is, what we always aim to have, and then the legal requirements. What I'm giving you is the best practice. If you're looking at your documents and they've been signed by you as the client, and they've been witnessed by 2 individuals and a notary, that's the best thing you can do. I recommend to all of my clients that we keep the people named in our documents, like our agent under our power of attorney, off of our signature blocks. We want disinterested people, those people who are not named in the document, to witness those. And I always recommend a notary as well. And the reason we like for you to sign those documents in the presence of 2 witnesses and a notary is to protect your wishes to be honored when we need to use those documents, and protect them from being challenged by other family members. You never want someone to question if your power of attorney is valid because the person you named and their significant other were the witnesses and your neighbor was the notary. You don't want anyone to think, oh, gee, was she pressured? Was he coerced? And so there are laws as well for the last will and testament. By law, you actually cannot be interested, meaning you cannot be named in the document. And all of those signatures must be notarized. And the last will and testament has a line of sight rule, which means the signor, the 2 witnesses, and the notary all must be in the same room within the line of sight of one another. So that's our witness and notary requirements. And so I want to speak for a moment on our next slide about this new law that's called our remote online notary. So this is new, and this is very, very important for our clients because it came into effect January 1st of this year. Now, let me be clear, this does not negate any documents that were notarized before 2020. So if your document is in 2019 or before, this new law is only going to be applicable to those signing new documents. This law came into effect because of, Florida. We've been talking about these online wills, which us lawyers are very concerned about. But it's really important when we're talking about a power of attorney and a health care surrogate and those other documents. We want to make sure that that notary is able to stamp that document without perhaps being in the room because of COVID lockdown procedures and things like that. What I want to tell you is, be wary of attorneys, of notaries, of anyone you know who says, oh, just sign the document on FaceTime and then mail me the originals and I'll stamp my stamp on it. That's not legally binding. So what we have, the new law that came out on January 1st, is allowing for a special remote online notary to take a course or a training. And they have to do very specific requirements by law, which will allow them to see you via FaceTime or Zoom and then notarize the document without physically being present. And so this is a major bonus for COVID-19 safety proceedings. But I really want everyone to be wary and look at those notary blocks. You need to make sure that your notary is saying by means of physical presence or online notarization before they put their stamp and their signature on it. The other thing I want you to be aware of is by law, that online notary cannot charge you over $25 for that online notarization. So make sure they're only charging you $25 for that service, and they can only charge you up to $20 to deliver you that copy. So if you're seeing anything above $45 total for all of those services, that notary is not doing what they're supposed to be doing, and you should not be utilizing their services. Okay, so on the next slide here, we're going to talk about what happens if I don't have a power of attorney or health care surrogate. Okay, so if you have capacity Now is the time to do it. So these documents, it's very important to understand that we have a lot of clients calling my office saying, you know, my parent has dementia, and so they can't sign anything. Well, that's not necessarily the case. Capacity is, of course, in flux a lot. Sometimes people have good days and bad. Sometimes we're better in the morning, and then we have sundowners in the afternoons and the evenings. And so it's important to consult with medical providers, but also an attorney. Because if I'm able to travel out and have a conversation with someone and I feel like they are understanding of the situation and the people who they are naming, then we can sign those new documents. So always what I tell my clients is never assume anything. Talk to those lawyers, ask those questions. If you don't have a document, now's the time to sign them. And if you have an old document, the Health Care Surrogate, the power of attorney, that HIPAA, all those documents can be completely amended and revoked and authorized and changed and things like that. Okay, so what happens though if we don't have capacity? Like Caroline was talking about getting hit with that semi as a pedestrian, right? If we don't have anything planned, we're going to be looking at guardianship. And what guardianship is we are physically having someone's rights removed from them and placed with someone else. That differs from the power of attorney and the Health Care Surrogate, because those documents, when they're signed, authorize us to share our rights with those individuals. And guardianship, like Caroline mentioned, is very expensive and it's very time consuming for those proceedings in court. So on the next slide, I'm going to give you a little overview, a little breakdown of what that guardianship proceeding really looks like, okay? Our hope always is that it is never, never necessary. This is always a very last resort, okay? But so what happens is your family members or the hospital or strangers for that matter, if we don't have anyone named, they're going to file paperwork with the court saying this person has a level of incapacity. Maybe it's holistic. Maybe that person is non-responsive, cannot go to the bank, cannot communicate, can't make any medical decisions for themselves. Or sometimes it's limited, right? So this person can communicate with doctors and still understands their medical decision, but they cannot manage those finances or apply for Medicaid benefits or, you know, make sure that we're not selling all of our stock. And so the court, by law, once that paperwork is filed, will appoint an attorney to represent that alleged incapacitated person. Caroline mentioned that pre-need guardian, and though it's very important, I always tell my clients, we don't get away from the guardianship proceedings. So by law, whenever something is filed in court over someone's incapacity, an attorney will be appointed for that person's best interest, just to make sure that the family's doing everything on the up and up. And again, that's why it gets so very expensive. The court is also going to appoint examining committee members. Those are 3 medical professionals who are going to come out. No one takes our word for it. We always double check everything. So those 3 individuals are going to look at that person's incapacity levels. They are going to do a mental evaluation to determine that person's capacity and submit those reports to the court. Now, the next step that happens is we have a hearing in front of the judge. All family members have to be given notice of a hearing. And so if someone has 6 children, those 6 children are going to get that hearing notification where they can come to the court and fight over who's in charge of that person. The court will look at those examining committee reports. They will hear from the attorney for the alleged incapacitated person. And at that point, the court is going to decide what rights are removed from someone and placed with the guardian. And the courts are going to select who that guardian is going to be, which is why if we ever have a guardianship proceeding happening, that pre-need guardian paperwork is so very important, because that will tell the court who we wish, when we had capacity, for that for that individual to be for our guardian. And so what I always tell my clients is, it is very important to keep those power of attorney and healthcare surrogates updated, because if we are in a guardianship, it is ongoing for the entire lifetime of that individual, and it is always overseen by the court every single year for every single penny spent, and every major decision is going to be overseen by that court. And so that's a brief overview of our guardianship proceedings. And so I'm sure we have some time for questions, Candace.
Thank you, Carla. That was a lot of really great information. I would like to go ahead and open it up for questions. If you have a question, please type it into the chat box. I'm going to start with, I had a few questions that were emailed to me last night and this morning. So let me go ahead and stop my screen share, and I'm going to start with those. And while we have more questions that come in from our viewers. So I had a question that said, if my legal papers have been filed with one county and I move to another county, do my papers need to be filed in the new county's courthouse? Would either of you like to answer that?
I can. So as a matter of privacy for my clients, I rarely file or record power of attorney and healthcare surrogates in the public record. The only thing that I ever submit to a county is the pre-need guardian. If you do locate to a new county, I do recommend submitting that pre-need guardian to the new county you reside in, but I do not normally recommend submitting anything in the matter of public record.
Right, I agree, unless they're talking about a will after somebody passed, and only then does the will get filed. Some people think they need to file right away, but just like Carla said, generally you don't file any of these papers. Maybe the only one might want to file is the pre-need guardian declaration.
Okay, great, thank you. And just a following question off of that I just got was, so the POA does not need to be registered with the county. Is this true in all states?
I'm only licensed in Florida, so I can only comment on the Florida law portion of that. But if you have a power of attorney and you live in Florida, I do not recommend putting it on the public record or recording it.
I agree, and I'm only licensed in Florida too, so I can't speak to the other states. However, sometimes people take a copy of the power of attorney to their primary bank. You don't give it out like candy, because it is a powerful document, and in the wrong hands, it could be used to clean somebody out. So the only entity that you would want to share it with would be the primary bank, if at all. And that is usually because the bank is legally allowed to have up to 10 days to process the power of attorney. So if all of a sudden somebody is incapacitated, maybe by a car accident or a stroke, the bank could take up to 10 days if the power of attorney is then walked over to the bank. So some people prefer to go ahead and get that lined up ahead of time to make sure that the bank has that ready to go. Otherwise, no, you do not have to register or file or do anything with that power of attorney other than keep it guarded like gold, because you don't want it to go into the wrong hands. And copies of the original are just as good as an original, so that is dangerous as well.
Thank you, Caroline and Carla. Another question I have said, I live in South Carolina. How much of what you spoke about crosses over state lines?
So I'm not licensed in South Carolina, but what I will say is if you are a Florida resident, when you sign any of these documents, they are a valid and binding document. If you are a resident of another state and you do have a legal document that's validly executed in the state where you reside and you bring it to Florida, Florida will honor a legally binding document that's executed in that state. I'd get that in writing, though, from an attorney that it was properly executed in that state, because we want people to be able to rely on those documents. It is my recommendation if you move that you do update your documents to the state where you're living in.
Yeah, I agree completely.
Good, thank you. Another question, is it absolutely necessary to have an attorney complete forms like Health Care Surrogate or will?
Can you repeat that?
Is it absolutely necessary to have an attorney complete the forms like a healthcare surrogate or a will?
Well, just like my example with the accident with a semi, if somebody were to complete those forms by themselves, it could run a risk of not complying with the Florida law. A lot of internet forms do not comply with the current Florida law. So the person runs the risk of having just at least a paper, a document, but it might not be effective when the time comes to need it. And so it would be a minimum level of protection, kind of like being in an old car with no safety measures.
My example on that is I find legal documents to be just as important as medical advice. And so I don't go on WebMD and try to diagnose myself. I go to a doctor. Right. If I need legal documents, I wouldn't do it online. I would go to a lawyer. But of course, you can have your own documents pulled offline. People do. It's a risk.
Yeah, and this judge that used to practice, he was a judge for 25 some years in this area. That's all he did. He didn't do any other type of law. And whenever attorneys came in with a client's documents that was done through the internet or self-made, he would roll his eyes and he'd say, oh, here we go. Because it was 9 times out of 10 trouble.
Great, thank you. So I have some more questions kind of continuously rolling in. I have, can you explain more about agent not being the caregiver on the power of attorney? I am the caregiver, but I am also the agent. Does that make sense?
Mm-hmm. I mean, it's not illegal. It's just can be challenged, like Carla had mentioned. If in other instances, the document can be challenged, and it runs the risk of two things: of being looked at with suspicion that there was some sort of nefarious reason for being on that document, the durable power of attorney, and there's also a risk of liability, extra liability, because it's more susceptible to being challenged. So I highly recommend that the person not act as agent of the durable power of attorney and caregiver, if at all possible. The only times perhaps is if the person has absolutely nobody else that they can trust. What do you think, Carla?
So, respectfully, everyone has their own opinions. My legal practice, I differ quite heavily in that. The reason being is because although I'm very, very, very particular about no one signing the document as a witness who's also a caregiver, I know a lot of families where the circle of trust is very close. And so the person on the power of attorney is in fact the person who's helping mom or helping dad out on a daily basis. They're the ones closest and most trusting. If you're doing it through a law office, when we come in, we have, our family members sit in the waiting room, and I only meet with my client so that there is no, coercion question. If my client says, I want this person to be my healthcare surrogate, and my power of attorney, absolutely. You know, that's family for you, right? But I disagree quite heavily on that one. I name often my healthcare surrogate and my power of attorney as the same people.
If there's absolutely nobody else that they completely trust, and it could be family that they don't trust, but if they, I encourage them to think about it and see if they could come up with anybody else that they might trust, whether it's a friend, neighbor, family, whatever, because that's the first, that would be the front line, and maybe an alternative would be caregiver, but I usually recommend against it.
Great, thank you. It looks like I'm kind of getting a lot of questions about if you move from one state to another. So really quickly, we'll answer this one. She said, I have legal guardianship of my brother who has special needs. If I move within the city after obtaining guardianship, do I need to file some type of change of address form with the courts?
Very much so. So there's Florida laws. The guardianship is established in the county where that alleged incapacitated person resides. And if we are moving or relocating outside of that county, I absolutely recommend them communicating with their attorney who did their guardianship for more specifics, but absolutely the court is going to need a notification.
And that would be the person needing the guardianship that would be moving from a different county, right?
Correct. Sorry. Yeah. So also to clarify, if the guardian moves, that's fine. But if the person the guardianship is over moves, they need to consult with their attorney.
Right.
Okay, great. Did I hear you say that a spouse should not have durable power of attorney for his or her spouse? That's another question.
I name spouses all the time. My spouse is my power of attorney.
Yeah.
The spouse should not sign as a witness for the person's power of attorney.
Okay.
And a spouse who has no power of attorney over the other spouse, and if there is no power of attorney at all, what I mentioned that might have been taken out of context was that that the spouse, even spouses are sometimes not able to access medical records or make decisions or access bank accounts that they're not on. So that's another reason for the importance of having these documents. But certainly the spouses are usually listed in the documents.
Great, thank you. What validates the power of attorney?
What validates?
I had a question. What validates the power of attorney?
So I would say that a power of attorney is a validly executed document, meaning it's a legally binding document. If the person signing it has capacity, if it is signed in the presence of two witnesses and a notary, that's my recommendation. Florida law states that it can be signed in the presence of two witnesses, and one of those witnesses can also be the notary. So rather than having person signing witness, witness, notary, it can be person signing witness, witness who is a notary. That's a valid, legally binding power of attorney. I also want to note on a tangent, but this is very, very, very important. The power of attorney laws changed in Florida in 2011. After 2011, your power of attorney must have initials by specific powers. So if you are looking up your power of attorney document and you're looking at it and it is signed after 2011, if you do not have specific initials next to specific powers, you need to update your document and call an attorney or go to who you did your document through. Very important.
Yeah, I'll go to somebody else. that person didn't know what they were doing. Those are called superpowers, and they're giving the agent extra powers to do certain things, and it gives them extra authority over certain things, like giving away gifts. So those are so supercharged powers, such supercharged powers that the legislature requires either initials or a signature by each one to show the intention of giving those powers away.
And that's 2011.
Yes.
I might have you send me something about that so I can share that with all the viewers via email. I think that is very important. So we'd like to make sure that everybody knows. So we have about 5 more minutes for questions. I still have a few more questions in here. I have, what is the average cost of having an estate planning drawn up by an attorney? I'm not sure if this is something either of you can answer, or if it kind of differs depending on where you get it done.
It differs on whether the person, focuses in this area or is just out of school, if they know what they're doing, how much is involved. I mean, how would you answer that, Carla?
So my office does flat fees. So a new power of attorney, health care surrogate, HIPAA, living will, pre-need guardian, and last will and testament for a husband and wife is $1,300. But, there's a lot of attorneys in the area.
Yeah.
I include all those along with that online access card, a binder if they want it. But mine is at $1,200 as a flat fee. But if there's been a few times where I've been on the 6th and 7th draft, and I mean it's substantive changes, which changes everything. So that results in more time spent on it. And then sometimes it's small changes. Like recently I had a couple in their intake form say that their son's name was Gregory with 2 G's, and then on the 6th draft they said no, it's 1 G. So anytime you make changes, it causes a lot of other, it's a domino effect that causes a lot of other changes. So I've started charging hourly after the 2nd draft.
Right. So it really just kind of depends. So thank you. So we have a couple more minutes. I have 3 more questions so far in the chat. We'll go ahead and answer those 3, I think, and then move on unless we have another pressing question come in. Do you recommend a trust over a will to avoid probate?
No.
I do. Everyone's a little different there. That's a very loaded question. I do though. I do.
I don't, if that's their only reason for having a trust. They're spending a lot of money over something that could be done more economically as far as titling things certain ways. There's other ways to avoid probate, and then avoiding probate it's almost never successful. I had this discussion with a previous judge who's now retired, and trusts are only necessary under certain circumstances. And if your only purpose is to avoid probate, then that's not a good enough reason to have a trust. I mean, I'll do it. I'd be happy to take the money, but ethically and honestly, I would recommend against it if that's their only reason.
Okay, thank you. 2 more questions. I'm not sure I understand understand this one. She said, I don't have a pre-need document, so how do I get one?
That's probably referring to the pre-need guardian. Any attorney's office in the area creates those, and it's a very simple document. It's only a page, so that's a quick call.
Okay, Thank you. And what's the difference between power of attorney and durable power of attorney?
That's a good one. And nowadays, currently, durable power of attorneys are the ones that are more commonly used. But durable power of attorney continues to exist even up to the date of death. So even if a person becomes incapacitated, a durable power of attorney stays in effect. Whereas the other power of attorney is not necessarily, in fact, I don't even know if they're even used anymore, really. Certain powers of attorneys are used for very limited purposes. For example, if somebody goes overseas because they're in the military, they might leave behind a power of attorney with their spouse. But most powers of attorneys are the durable ones.
It's a good question. It is a good question. When I say power of attorney, I do mean durable power of attorney. All of the attorneys in the area, when they say power of attorney or POA, they are executing a durable power of attorney, because that's the goal of the document. You want the document to be there if you lose capacity. So it's a valid question. It's us attorneys get lazy. We drop the durable, but they are durable.
Okay, thank you. Let me see. I think that was, I had someone ask if the last will was created, the living will, in 2012, should it be updated?
Yes.
Go ahead, Caroline.
Okay, sorry. Generally, yes, especially if there have been a change in circumstances. Say if people in their family or the beneficiaries listed there have passed away, or if there's new children or grandchildren that they want to include, if they've got new property, any major change in circumstances, which usually happen within 10 years, 12 years, 10 years, even less. And then the laws change as well. So, the tax laws have changed significantly. So all these things go into, are factored in as far as deciding whether or not they need to make some revisions.
I agree.
Okay, awesome. Thank you. We're kind of nearing the end of our time.
I've got one more thing about back to the durable power of attorney. I said they're effective until the person passes away. And then after that, if there's a will, then the personal representative takes over the financial managing of the estate. A lot of people think this durable power of attorney continues on forever and ever, even past death. And so I want to make clear that it does switches over, and sometimes it's different people. So the power of attorney shuts down on the date of death, and then the personal representative steps up and starts serving. And if there is no will, then the Florida law decides. It has a list of priority over who should first be appointed as the personal representative. So the judge decides who would be best to be appointed.
Thank you, Caroline. And thank you, Carla. Thank you both for sharing your expertise with us. I know I feel a little bit more comfortable with the legal jargon and the documents and everything. So I really hope that our viewers feel the same way. I would like to go ahead. We're going to try something a little bit different. Let me go ahead and screen share again. But we would like to do, I'm going to share a poll with our viewers. You're going to see that come up on your screen in just a moment. I think if you're joining by phone, it might not come up, but if you're joining online or through the Zoom app on your desktop, then you should see the poll, and it's very quick. I'm going to go ahead and launch it right now. It's very quick. It's only 5 questions. And like I said earlier in the session, it helps us improve. It helps us make sure that what we're doing is effective to you all. So If you do fill out the poll, then you're entered for a chance to win a $50 Amazon gift card. I'll be able to look at the names of those who have entered after the session, so I'll reach out via email. And then while you guys are filling out that poll, I'll give you a few minutes. Carla has a free gift that she would like to share with you all. So Carla, if you'd like to share.
Thank you. So us at our Burke Bryant family, so we have, there's about 3 attorneys here and we're up to 12 support. So we're a big family over here at Burke Bryant. We deal a lot with those families who are impacted by Alzheimer's. And so we have penned a book, and they're not too large. I promise they're readable. They're extremely informative. And we have one for, thank you, Candace.
I have a couple. You could see there, it's a pretty quick read.
We try to, yeah, we try not to make it too overwhelming. But so we have a book that is specifically for those caring for those individuals with Alzheimer's. And then we also have it for those of us who are living with the disease in the early stages. And so our number right there is our office number. The books are free. And so if you would like a copy of one or both, just go ahead and give a call over to our office and someone will get you those books.
All right, thank you. And like I said, I have my copies, so it could be very, very helpful to anyone that's viewing. Let me check on the poll, see how we're doing. Okay, we're doing pretty good. I'm gonna go ahead and leave it open. And I'd like to announce, sorry about the writing that's on the screen. I don't know if I did that or if that was accidentally someone else. I'm not sure. I'd like to go ahead and announce our next session. It's going to be Saturday, July 18th, and we'll be talking about preparing for a crisis during a crisis. So discussing the disaster preparedness in the time of COVID-19. You know, hurricane season is in full swing, and we want to make sure that caregivers are aware of any changes and recommendations in case anybody has to evacuate. Fingers crossed not, but we do want to be prepared. I'll be sending information on the session out as soon as the details unfold. I encourage you to check out our website to sign up for the Caring Together newsletter. You can see the email there, or the website there, caregivercoalition.org. We'll keep on sharing the resources as events and coalition updates. They're going to get sent right to your email. You can also like us on Facebook, Caregiver Coalition of Northeast Florida. If you have any other questions, you can reach out to me directly or visit our website, caregivercoalition.org. There's, at the bottom of the website, there's a questions or comments form, and those messages get sent straight to my email so I can answer you directly. But if you guys don't have any other information to share, then we're pretty ready to wrap up. I really appreciate you guys joining us. I appreciate everybody that participated, everyone that asked questions. And we look forward to seeing you guys next month.